Hello, everyone, and welcome to Wage and Hour Compliance in the World of PAGA Reform, presented by Infinium HR. This is a re-recording of the live webinar event for the HR Pro Conference 2025. Let's get started. So first, a legal disclaimer. If you guys can read through that, that would be fabulous. Give you a moment. We do our best to try to get everything right, but at times things change out there or we may miss something. So I want to make sure we apply this legal disclaimer. Okay, so let's look at the agenda for this webinar. We'll do an introduction. We'll look at PAGA reform. We'll then dive into the wage and hour compliance issues that are most prominent with regards to PAGA reform, including employee classifications, overtime and regular rate of pay, meal and rest breaks, most common wage claims, timekeeping and payroll accuracy, final paycheck and wage requirements, sick leave and leave compliance, and finally we'll end up with an action plan for 2025. And as I mentioned, we'll provide a bonus at the end on what to do if you do face a PAGA claim. Okay, so introduction. First of all, we're all facing the same challenge, right? Wage and hour laws are complex. They're ever changing in California. It's probably one of the worst states to do business in. PAGA reform has mitigated some of the risk for employers, but compliance proactively and reactively is still very critical. Non-compliance can lead to lawsuits, penalties, and wage theft claims. And even outside of PAGA, lawsuits can still be filed. There's a lot of very aggressive attorneys out there, we'll put it that way, and they want to take advantage of your business. So you have to protect yourself. Okay, so what's PAGA? So PAGA is a Private Attorneys General Act. It allows employees to sue employers for labor violations on behalf of the state. It used to be that you would go to the labor board and you would file a claim. They were usually very small. They didn't have the resources. They really didn't have a mechanism in place to bring attorneys into it. So I believe what most likely happened is that the attorneys lobbied the state and offered to help employees sue, which we're basically making the employee the private attorney in this case. It was reformed in 2024 to reduce frivolous lawsuits, limit excessive penalties, and provide some businesses with more opportunities to address compliance issues before facing litigation. So that was huge. Here's some of the key changes that occurred. Lawsuits are now very limited in scope. They emphasize arbitration and alternative dispute resolution. So basically getting that outside the court realm. The state now has more authority to step in and review a case and intervene before it becomes a major case. There are caps on penalties for minor technical violations, where it used to be a minor technical violation could wind up being a six-figure or even seven-figure lawsuit. And businesses that implement a proactive compliance program can be shielded or may be shielded from some claims. And employees can now opt out where it was a little bit more difficult before. So how do you leverage all this? So first of all, you really must evaluate your current practices. Do a thorough review of your payroll, timekeeping, employment practices, like how you pay people, how people are classified, how you finalize paychecks when somebody leaves the company, things of that nature. Make sure that you're in compliance with California labor law. Implement a compliance program. So it means to basically establish a certified program where you have a specific plan in place to review payroll, review your records on a regular basis, and you can really reduce your liability and benefit from these new PAGA protections by putting something that's proactive and is regular, and that you document that you are going through and reviewing your payroll on that regular basis. Very important. Another way to protect yourself and leverage this is to use an alternative dispute agreement, or used to be arbitration is what it's called. It's legal now. There's a window of time here where we can get these in place in California. They're not very expensive, maybe $1,000 to $2,000 to put one in place in your business. So I really highly recommend that you look at that. And again, regularly audit employment policies and your practices, handbooks. Keep everything up to date. Don't allow years to go by before you update your policies or update your handbook. Get some help, engage in legal counsel, work with HR people on the outside to help you so that you get like a second set of eyes, on your practices and on your policies. That could be really, really helpful. Another way to really protect yourself is to manage wage disputes proactively and reactively, right? So if an employee complains, make sure you document, investigate, promptly, step in and really conduct an investigation to find out what's going on. Is there any truth to what they're complaining about? And, can we fix it? And that's where this reactive really resolution comes in. But proactive meaning before we get to a PAGA lawsuit, right? So really step in, try to resolve the issue with the employee, document everything that you're doing, pay them quickly. You can maybe offer penalties, maybe offer some additional pay, whatever it takes to really get them to just accept the resolution, and make sure you get that resolution in writing. And then maintain compliance records. Any complaints that do happen, make sure you keep them in writing in the employee folder or a special complaint folder. What the resolution was, that you made sure that you were in compliance as far as the resolution goes. And then this will help strengthen any claims that may come as a result of that, and hopefully that resolves it for good. So some action steps would be to create a clear process for employees to report concerns, right? Don't make it hard for them to complain about something. Make sure that there's an open door policy, and there's a two-way street that they can come without any fear of retaliation to complain. Again, document anything that is any employee that complains and whatever actions you took to address that. And then provide regular training to managers on handling employee grievances. We've seen cases in the past where managers really didn't feel it was a big issue, and they, basically kind of poo-pooed it and let it go. So make sure that you are let them know that it's very, very important for them to handle any grievances quickly. Okay, so now let's dive into wage and hour compliance. We're not going to get really, really deep. I want to just touch on some of these. These laws are so complicated, it would just take up way too much time. So, okay, let's look at employee classification errors. First of all, you should really go in and review your hourly, non-exempt, and salary-exempt employees. Make sure that they're classified correctly. Salary-exempt must meet minimum qualifications. They've got to be like a manager or have some sort of significant control over the business, and they must be paid 2 times minimum wage. Commissioned salespeople can be set up as exempt as well, that they must spend more than 50% of their time outside sales. You cannot do that from inside sales. You can, but it's very difficult. A lot of their commission has to be from, or a lot of their pay has to be from commission. So review your hourly pays employees as well. Make sure that if they receive any kind of non-discretionary bonuses or commission, or they have multiple pay rates, they must be paid using the regular rate of pay, which would apply to overtime, meal break errors, and sick pay. And we'll talk about that in a little bit. Independent contractors must meet the ABC rule, which is they've got to be free of direction and control. They've got to do work that is outside the usual course of your business, right? So if you make widgets and they have anything to do with making widgets, then they would not fall outside that. And they've got to be some sort of an independent business, that they do this work for other people. And if you fail any of these 3 rules, they're not an independent contractor. So it is very, very difficult to have independent contractors that are not somebody that just, maybe it's your IT person that comes in, or a maid service that comes in at the end of the day. So really, really review those issues. And you must have freelance agreements for anything over $250 per project, or an aggregate amount of $250 over 120 days. So this might be a social media person, a photographer that comes in, video people. Make sure that you have an agreement in place that spells out everything from the type of projects, the amount of pay, and that they get paid within 30 days. So that's a new special rule in 2025. And, these things can really, really mess things up as far as overtime and minimum wage. They can really turn into some big lawsuits. So really, really review all positions at your company. Okay, so we mentioned regular rate of pay and overtime. So first of all, we'll talk about overtime. Overtime is 1.5 times the regular rate of pay, as I mentioned. Over 8 hours is, or 40 in a week, or 8 hours in a day, or 40 in a week, and on the 7th consecutive day in a work week. Make sure you establish your work week that is either from Sunday to Saturday or Saturday to Friday or whatever it is. Make sure you understand that. And if somebody jumps over that 7th or 8th day, whatever, into a new week, then that doesn't count. That's a brand new week, and you don't have to pay that additional. So make sure you understand your work week and your work day. Double time applies after 12 hours in a day or in work excess of 8 hours on the 7th consecutive day in a work week. Then the regular rate of pay, again, this is basically just an average of all the hours worked divided by the total pay. And that is going to include non-discretionary bonuses, which mean that it's a production bonus or that the employee knew what they were doing, knew what they needed to do to earn that bonus, and they received a bonus. Could be even a profit related, it could be just about anything. But then commissions or any kind of split differentials in their pay, they must be included. That must be included in regular rate of pay. And then overtime sick pay and meal break violations must be paid at the regular rate of pay, right? So make sure you're able to calculate that and the employees are paid correctly and it's itemized on the paycheck. That's very important. And it's kind of what it looks like. It's kind of a complicated little, not so complicated, actually, a little calculation. But if you got an employee that works two different rates, one is 30 and one is 40, they work for 30 hours, make 900. They work for 15 hours at the higher rate. They get paid 600. Their total pay for that week is 1,500, and they worked 45 hours. So they also made a little bonus or a little commission at the end of the week of $325, meaning their total pay now is $1,825 for the week. So we just simply take the hours worked and the total pay. We divide the total pay by 45 hours, and we get our regular rate of pay. So they basically averaged $40.56 during the week. The overtime premium rate would be $20.28. So now any overtime premium must be paid at that $20.28. And this means for that particular week, the 5 hours that they worked overtime is now paid at $101.39. Their total pay for that week is $1926.39. So that's how you do that. You can automate this process. Most timekeeping systems will do it. Make sure you talk to your payroll company. Ask them if they are able to automate the regular rate of pay in your timekeeping system. And so in California, it's we already went through all this, so I'm not going to detail this, but make sure you're looking at all these things. If any of these types of pay apply to your workers, then make sure that you have a system to calculate this regular rate of pay. Okay, so meal and rest breaks are probably one of the biggest worries or the biggest lawsuit generators, I think, because they're so easy to track and they're easy to prove that they're out of compliance. So as you know, meal breaks must be provided before the 5th hour. That means the minute you hit 5 hours, you are beyond, you're late. The employee's late. And they've got to be no later than 30 minutes, right? You can use meal break waivers if somebody's going to work less than 6 hours or less than 10 hours in a day. So the first meal break must occur before 6. If they work less than that, they can sign a waiver. And you can have a blanket waiver on file, but you really should get that in writing every single time that they wish to waive their meal break. You can do it on an attestation in a time card system, timekeeping system, or you can have somebody email you or text you or something. Just make sure you get that in writing. And then for that second meal break, which would happen before the 10th hour, you can waive that as well, as long as they didn't waive the first meal break. They took their meal break on time and then they got to 10 hours. And it's like, 10 hours is going to finish my day, so I'm going to waive that second meal break. So again, each time in writing, very important. Rest breaks are required for every 4 hours worked or a major portion thereof. thereof. We've had some questions where, well, they only work 3 hours. And it's like, do you really want to get into an argument over, 20 minutes, 10 minutes, and have any potential lawsuit on your hands? It's just not worth it. Anytime they get close to 3 hours, make sure they get a 10-minute break. Do not combine rest breaks and meal breaks. We still see companies doing that figure, they're just going to take a 40-minute break and not take their rest break in the morning. Not a good idea. Make sure that they're separated and, again, split somewhere in the middle of those time periods. Penalties will apply if the breaks go past that 5th hour or even a minute short, even seconds short. And, it's very dangerous to kind of play around with those times. So, have your employees maybe take a break at 4 hours instead of getting close to the 5th hour, and set your lunch break for 35 minutes. Might be a way to kind of get out of that close threshold. So here's some meal break practices. So common mistakes are, just not tracking them electronically. You can have an employee write down on a piece of paper what their lunch was, but how do you know that's when they actually took a break? You don't, and they can use that against you. You can allow employees to work through meal breaks and without waivers. Maybe they just kind of needed to get back on the job and took a short lunch, or they're just kind of didn't feel like taking a break that day. That's a huge mistake. Make sure you take the breaks at the right time. Again, have a scheduled time where your employees go to meal break and rest break, and then not properly compensating them for missed breaks. So if you do have a missed break, you see a short break or it's too late in the day, then pay that meal break waiver or meal break penalty, which is a 1 hour penalty paid at their regular rate of pay, as we discussed earlier. Another bad issue is not paying meal break violations for non-compliant meal breaks. So really, I kind of said the same thing here, so I do apologize, but make sure you're paying those employees meal breaks. And, you can really, really automate this. And I think we can talk about that here. So you can automate meal break violation alerts. You can have your system automatically pay a meal break when there's an issue. You would have a final approval before that happens, but don't mess with the meal break issue. Don't automatically waive a meal break penalty just because you didn't feel like paying it. You got to make sure you do those things. Train your managers and supervisors on what these laws mean, and make sure that they are tracking your employees and ensuring that they go to lunch on time. Make sure the employees know their rights and that you have a strong meal break and rest break policy within your business. Very important. And then, review your records. Should be every single week. You're trying to catch any errors in either timekeeping, overtime, meal breaks, correct them immediately. We'll talk about that a little bit later. And then, if you're not sure and you want somebody to come in and take a look at it, have an HR person or an attorney or somebody that understands these laws. Have them just come in and take a look at it. But if you're not sure, get some help. Okay, let's talk about payroll accuracy. So first of all, obviously, let's maintain accurate payroll records. Keep detailed records of all hours worked, wages paid, overtime calculations, and deductions for at least 4 years. It says 3 years, but you go 4 years. You got to keep personnel files that long anyway. So make sure you keep those things around because they will get pulled into a lawsuit. And then be sure to extract your wage and hour data when you switch payroll companies. We've had some issues ourselves in our staffing company where we had used a couple different payroll systems over the course of a couple of years and got called into a lawsuit, and we had to go back and backtrack and try to find all that data and pull it, and it took months to do that. So it's really not a good thing to have it spread everywhere. When you leave a company, make sure you download all that data, put it into an electronic file somewhere. And then, of course, legally compliant wage statements. They must include gross, net wages, total hours worked, the pay period dates, overtime details, deductions, and available sick leave. You've got to have that on their paycheck now. The official name of the business, not the DBA, but the corporate name of the business and address must be listed on the pay stub and on the check. So you can get basically more pain added to a lawsuit if you just neglect any of those details. So ensure timely and correct pay. Of course, if they're supposed to be paid on, every other Friday or the 15th or the 31st or the 1st, whatever, make sure that they're paid in full, all the overtime, all the meal break penalties, everything that was included in that pay period, they are paid as required by law. And then if you do make a mistake, correct it immediately. Don't wait until the next pay period to add that money back or to give them any penalties. Cut them a check. Just show that the minute you knew there was an issue, rectify it as soon as possible. And that will help you avoid any penalties, especially with this new PAGA reform. And then keep up with California laws. They're always changing. Minimum wage is changing. And depending on the cities you're working in, some cities have higher minimum wages or higher sick leave requirements. So just make sure that you understand where you're working, what the laws are, and that you're being updated some way, whether it's an HR company or you've got a law firm that's sending out data. Make sure you're just keeping up on that all the time. And then, utilize a reliable payroll system. I'm always surprised that some of the bigger payroll companies really, really don't proactively let their clients know what they should be doing as far as compliance goes. So if your payroll company is not reaching out to you, especially here in California, and you're using a national provider, I won't name any names, but if you're using one of those companies and they're not telling you that, hey, you need to do this or you need to do that, here's some information, hey, here's what our system can do, then you probably need to find another payroll company. You shouldn't be chasing them down for information. Your payroll company should be helping you to stay compliant with wage and hour laws. We're not going to do your HR for you, but the wage and hour, as far as tracking things and meal breaks and things of that nature, very, very important that they're proactively assisting you. Okay, timekeeping. So, non-exempt employees' hours, they have to be recorded, right? Overtime's got to be tracked, paid correctly. Meal and breaks must be documented. Not so much rest breaks. As long as you have it in writing that the employee must take a rest break, that's okay. But really make sure you're documenting when they take the meal breaks. Again, you've got to keep 4 years of timekeeping records as well, not just your payroll records. Don't alter time records without justification, just because you don't want to pay that meal break. And when you do, get their initials or have them approve a time card in a time system, however you can do that. Do not allow off the clock work. There's no more de minimis time. So if they're just on the way out to the car and the parking lot and they're going to take their trash with you, they're still working. So even those little things, have them do that while they're on the clock. Don't have even minimal work done. And then, failing to compensate for all the hours worked, that's pretty obviously, but including training, travel time. If your employees travel a long way, you've got to have some period of time and distance that kicks in, maybe 60 miles, 50 miles, or an hour, that they begin to get travel time. And you can pay them less, but make sure that you're tracking those times. And then do not round time punches. This is just not legal anymore. Not even, certainly not meal break issues that came up a couple of years ago, but any time, do not round it. Like if your employees are coming in around 8 o'clock every day and they're writing 8 o'clock on a piece of paper, that's rounding time punches. So that's why electronic to the minute is much more, prudent and much more compliant. So don't round time punches anymore. This is just not a practice. It's the law. You got to protect your business, keep records for that 4-year period, and make sure everybody's paid fairly. That's going to help you avoid a lot of costly disputes, because wage and hour claims, again, they're very provable. And sometimes it's harder to disprove if you don't have everything clearly accounted for. All right, so here's some best practices. Again, put it in timekeeping. If you don't have a timekeeping system, make sure you get one in place quickly. You can use an outside system, or your payroll company should have an integrated time tracking system that you can use. You can automate punch restrictions. So that means that your employees cannot clock in less than 30 minutes. That will prevent the short meal break. You can automate regular rate of pay calculations. So you're not doing a calculation in the spreadsheet every week, because that would be ridiculous. And then just create strong policies. Make sure your employees understand exactly what your company offers and what's expected out of them, and make them responsible for tracking their time correctly. We get a lot of complaints, well, my employees don't want to log in and they have trouble clocking it. You know what? Your employees need to be responsible. And if they're not doing things right, then you can discipline them, right? So we constantly reminding them, this is our policy, and you can get into suspension if you're not clocking in right, because your company can't afford a potential lawsuit. And then enforce. That's what I'm saying. Enforce overtime and break compliance. Do that with discipline if necessary. Regularly audit your time cards. Just check them every single week. They need to be done. Correct those errors immediately. Go to the employee, ask them what happened, fix it, get it in writing. Require manager oversight. Make sure that your managers at the lowest level down are really, really tracking everything, and you're maintaining those records for 4 years. Prevent that off the clock work. No de minimis allowances. That means not even 30 seconds, a minute, half a minute. It's to the second now. And again, discipline promptly and consistently. That's important for failure to abide by rules. And then, seek guidance when you need it. If you're having trouble, have somebody come in and do an audit and help you get through that. Okay, let's look at final paychecks. So final paychecks, employee quits within 72 hours or more, with 72 hours or more notice, then you can pay them on the last day of their notice. And they've got to have it at the end of the day. No, well, payday's tomorrow, so we'll just go ahead and include your paycheck on Friday. If their last day is on a Thursday and your payday is on a Friday, pay them Thursday. Okay. If they quit with less than 72 hours notice, you have 72 hours to pay them, but don't let that go into a weekend. So if they quit on a Thursday, 72 hours is going to be on Sunday. And unless you've got a way to pay them on Sunday, make sure you pay them Friday before the weekend hits. And then if you terminate that employee, you've got to have that pay immediately. It's got to be at the workplace where they typically work. You can, I think we talk about this a little bit later, but you can work out a deal where you mail an employee if they don't want to come back to work and they abandon their job, and you fire them over the phone or by text, then you got to get that paycheck to them. Unless you get it in writing that they're allowing you to mail it to their home or direct deposit, then I would not do that. I would make sure you get that paycheck to them immediately. And then again, what must be included? All earned wages through the last day worked, accrued but unused vacation time if you have vacation. Sick time is not included in pay. Overtime pay, bonuses, and then commissions if they're earned and it's calculable. A lot of times commissions have very specific conditions that they must meet in order to be earned, and make sure that you have that in writing if you do have commission salespeople. And then any expense reimbursements to basically everything. Make sure you got everything, paid to that employee on that last day. So some best practices. What you can't do is you can't hold final pay for unreturned equipment, right? They got a computer, they got some tools, and you want those things back, of course, but don't hold their pay. Do that outside the pay. Get them their final pay stub. That prevents any kind of lawsuits. Do not delay payment so you can process payroll on a particular day. Pay them whenever it's due, according to what we just talked about. Do not deduct any authorized expenses from final wages. This is why I don't believe in doing loans for employees, because if they leave or you have to fire them, you really don't have a way to get that money back within the paycheck. So don't do that. Don't take all the health insurance out. Don't just let that final paycheck be very clean with no extra deductions, and any money that they owe you, do that outside the paycheck. Don't require them to, drive to a different location or, have to drive all over town to go get a pay stub. They should get that right at their normal work site. And then best practices for compliance: prepare final pay in advance. If you know you're going to terminate somebody, have that payroll already in advance, ready to go, the final paycheck. You can use direct deposit, but make sure you get it in writing. Provide a wage statement, right? So make sure that they get their pay stub, clear breakdown of all the final wages. You can also give them a final paycheck acknowledgement, which they would sign that they've received it. All the details of the wages that were included in that, wages and hours. And then also you should be providing a 4-year benefit, which is a California EDD unemployment booklet. Make sure that they get that when they are terminated or when they leave as well. And again, keep these things for 4 years. I know I keep saying that, but that's important. And then what about unclaimed checks? So you have an employee that basically abandons their job, or they've got property on your premise. Make sure you do everything you can to let them know, including phone calls, text, email. You can mail it to them, or you can mail a notice that their paycheck is there, do it certified. I wouldn't necessarily mail it to their property, their last address on file, because you don't know if that address is correct. So make sure you get their approval before you do that, but track them down, show that you've been tracking them down. And then at a certain point, if they don't pick it up, there are some HR folks that say, well, just go ahead and mail it or go ahead and overnight it to them. You can do that. That's definitely an option. If, let's say, 2-3 days goes by and they haven't responded to you, go ahead and mail it to them. But, sometimes it's not going to be too helpful. What you'd want to do is hang on to that property or that final paycheck, and then you would file that with the state. And you'll know, as long as you do the right kind of mail, certified mail, or do it FedEx and requiring a signature by that person. As long as you're doing that, then you know that it came back, and now you can prove, hey, we mail it to their last known address and it came back. But I've had some situations in front of a labor board where that didn't actually work. So, just be careful, do everything you're supposed to do to try to get hold of that employee. Okay, let's talk about paid sick leave a little bit. So it's not really a wage and hour thing, but it kind of is. So you got to provide paid sick leave. It's now 5 days or 40 hours. They need to get that in 90 days. You can do it by accrual, 1 hour for every 30 hours worked. Which is going to give you a lot more over the course of a year, but you only have to give them the 5 days. But you can also do that in a lump sum, which if you have regular full-time employees, just give it to them in a lump sum. Makes it a lot easier. It's not advised that you request any kind of physician note when they're legally within their legally mandated time off. So their third or fourth day off. You probably shouldn't ask them for any kind of physician's note. It's sort of getting into their privacy, and it's almost basically in a way denying them their right to take time off for whatever purpose necessary for them, right? And sick time can be used for basically the employee's health condition. Now, I put quotes around the health because I have some employers that say, well, they need to be sick. They can't just take time off. Well, it might be mental health, right? They might need to go to Disneyland to feel better about themselves, right? So just don't question it when it's in that 5 hours. But then when it does become excessive, then we can get into dealing with those absences and excessive absences from an HR standpoint. But under the 5 hours, don't even question it. Just let them do what they got to do. They could be caring for a family member, right? It could be domestic violence or sexual assault. So you really don't want to get into a situation where you are asking all those questions, because now it is it's a privacy issue. Okay, let's look at an action plan. I've spelled action wrong, but you guys get the picture. So take proactive action, right? So again, compliance audits, go through, do what you have to do, and automate everything you possibly can. You can automate everything from time card approvals, regular rate of pay, as we've said, meal break restrictions, meal break violations. You can also have the employees attest at the end of the day that they took all their rest and meal breaks using a lot of time systems. That's kind of cool. And you can implement like a certified compliance program. We talked about that a little bit, and we'll talk about it at the end, where that just means that you have a very specific set of rules that you live by to ensure compliance within all the wage and hour laws. Train your managers and your HR teams and make sure that they understand what wage and hour laws exist and how to comply. And then ensure, handling of final paychecks, employee departures, track all that, keep it in keep it documented. Maintain detailed payroll, employment records, as we've said. Engage legal and HR support for any high-risk issues. So anything that's outside the circle. I call it the circle. The circle is normal every single week. Person works 40 hours a week and they get paid and there's no issues. But anything outside that circle, get some help. And you can even have them come in and do an HR compliance review with somebody that's qualified for this, or an employment attorney. It's worth it to spend a little bit of money to make sure that you are compliant. Okay, so again, that was not everything within wage and hour, but it was the big stuff that is going to get you in trouble if you don't get it right. There are some other issues like on-call pay and things of that nature. And if you have any questions on that, you can always reach out to us. Okay, so a little bit of bonus PAGA information. So again, implement that certified compliance program, conduct a full labor audit, develop policies and procedures to address all these legals. Get it in your handbook. Let your employees know that this is our policy for on-call, for overtime, for minimum wage, for meal breaks, all those things. Get that in your handbook. Provide ongoing training for employees and management. Everybody needs to know that this is how you do things. Establish an internal reporting system, as we said, making sure employees can come to you with a complaint if they have any, and they can get that resolved quickly. And then partner with an HR provider or an attorney to help you to kind of bolster that compliance program. When they see a third party, when these lawyers or judges, they see a third party that's involved in your plan and your program, then that's going to be a little bit stronger as well. Okay. So if you receive a PAGA notice, I won't get into too much detail here because I'm really not an attorney, but take it seriously, right? Review it. What are the dates? What are the issues? Get legal counsel on it immediately. Don't wait. Notify anybody that needs to know, managers of the employee, whoever that might be, and then begin to do an audit. Once you've identified what the problems are, figure it out. Go look and see, gosh, did we do this? Did we miss a meal break? Did we do not have a policy for this? What's going on? And then evaluate what that liability is. Is it serious? Is it small? Is it, something, what do we need to do about it? And then look at some settlement options. You may want to go to that employee and say, gosh, Mr. Employee, I'm so sorry. And you can reach out to the attorney firm and say, listen, we want to bring this to a quick resolution. Before you even have to respond to it officially, you may be able to settle it. So there's nothing wrong with that. But you certainly, it'll be tracked through the system, but you can certainly get to that attorney and try to settle that as quick as possible. And then you're going to respond to the Labor Workforce and Development Agency within 33 days. So you have 33 days to do all that stuff, 1 through 7 here. And it's a timed process. And then you want to implement any corrective measures. So if there was something wrong before that 33 days is up, show that you fixed it. We were not catching our meal break issues, short meal breaks. So we went ahead and implemented this meal break restriction and a notification process. We've put everything in place. That's going to really, really help you to maybe get through this without too much pain. And, prepare for potential litigation. You may end up going to court if it's something big. Just know that that's really going to impact your business, both time and money. So a little bit can be scary. And then, proactively prevent future claims. So once you've learned a little bit about this, make sure that you are going through and, you're fixing those issues so you don't have any of those issues in the future. Okay, so that was it. Thank you very much. This is a shorter version of the HR Pro Conference. And we're always here in Infinium HR. We are very HR focused here. We're very compliance focused and proactive in helping our clients manage all this between payroll taxes, payroll and tax management, HR support, compliance guidance, HR automation. We've got a very robust system. If there's anything that we can do for you, even on a consultative basis, please reach out to me. I'm more than happy to help you out. Okay, thanks very much, guys. Have a great day.